Hello friends, welcome back to the next session of the ownership and the possession concept under the jurisprudence. So friends, in the last and the previous sessions, we discussed about the different aspects of the ownership, meaning of the possession, and of course the categories and the elements of the possession. Now, in this video, we shall be looking into the kinds of the possession. So, let's get started with different kinds of the possession. So friends, when we did talk about the different kinds of the ownership, there was a slight change or rather a slight difference in the concepts when we were talking about different kinds of the ownership. The same is of course there when we are talking about the possession. So the first kind of the possession that we have to talk about is the corporeal possession. Now, of course, the corporeal means that physical existence. So those things which are having physical or material existence were in direct relationship with a thing which are possible. For example, houses or cars, as we discussed when we were talking about the ownership. So the possession of those property is called the corporeal possession. Therefore, corporeal possession is the possession of the material things which are movable as well as also the immovable properties. For an example, pen, book, wristwatch, car or house, etc. etc. The next kind would of course be the incorporeal possession. It means that the possession of the immaterial or intangible things, the things that we cannot physically touch or feel. So these things are which do not have the physical existence and therefore cannot be perceived by our senses. That means, as I stated, we cannot touch it or we cannot feel it. Therefore, the possession in respect of these things are known as the incorporeal possession. For an example, the possession of the copyright or the trademark or any of the goodwill of the company, etc. etc. According to Salmon, corporeal possession is the possession of an object wherein the incorporeal possession is the possession of a right. Now, if you remember, my friends, we did discuss about the Salmon's concept with regard to the incorporeal ownership when we were discussing the different kinds of the ownership. So, the same concept is applicable when it comes to the possession also. So the next kind is the mediate possession. Now it is the possession of a thing through another, either through his friends or servant or for agent, etc. As the thing remain in possession with another, the possessor has lesser degree of the physical control over such things. As an example, A purchased a house through his agent and the agent got the possession. Now A's possession is said to be the mediate possession. Why? Because the agent is having the immediate possession. Of course, when we discussed about the immediate possession, the next kind would be the same. It is also called as the direct possession. That means the object is right there in the physical control or rather in the physical possession or the primary possession of an individual. They are called as the immediate possession. Let's read what has been given on the screen. It is called as the direct possession, direct or the primary possession by the person over a particular object which acquires or gets directly or personally. In immediate possession, as the thing is in possession of the possessor directly, he has higher degree of the control over those things. It means that there is no other person holding that property. For an example, X has a car and he has kept it in his garage. Now this constitutes his immediate possession over his car. When we talked about the immediate possession, the possession of the owner or the possessor was not the immediate one, was not the direct one. Why? Because the agent was having the hold over that property and the agent's method of that possession would be called as the immediate one. Now let's talk about the next kind of the possession, which is the constructive possession. Now friends, the constructive possession is not actual possession. It is a possession in law and not possession in fact. That means according to Pollock and Wright, it is a possession which arises only by the construction of the law. For an example, the delivery of the keys of a building. That means, my friend, that I can be stated to have the possession of that flat which is there in the building when I have the key. But it is constructive possession because the possession is of the law and not of the fact. So the next kind of the possession is adverse possession. It means holding the land on his own behalf for some other person. If adverse possession continues peacefully and undisturbed for the number of years, like a lot of years of course, he can claim the ownership and the true owner's right of the ownership may get extinguished. That means, my friend, that this kind of possession existed when we are talking about long back aged. So, when we talked about the property issues that were there when the lease kind of the things, when the people were having lease of 100 years or 150 years and they were paying very minor amount, and they were not getting out of those places because they were having the adverse possession over those property for all this number of years, because it was peaceful enjoyment of the property, it was undisturbed, and he was holding that property on behalf of somebody else. He was using that property which was somebody else's, but he was in the adverse possession. So this is what you mean by the adverse possession. Now let's have a look at next kind of the possession, which is the de facto possession and the de jure possession. So what do you mean by de facto possession? De facto possession exists where the thing is in the immediate occupancy of a party. The person in de facto possession has the physical control of the thing to the exclusion of the other, has the animus and corpus over the material object. De facto possession may be described as actual possessions. That means factually, if somebody is holding that property in the possession, that will be known as the de facto possession. And legally, when the person will be having according to the law, when the person will be having the possession, but not of the nature of the de facto one, it will be known as the de jure one. So, the de jure possession can be described as the possession in law. It exists when the person claims a right of his own in the natural, normal, legal manner by occupying the thing without any dispute as to his legal right to possess and enjoy the thing. Legal possession may exist with or without the property in possession. In case of the de jure possession, it is possible that a man have ceased to live in the house, but without intending and to abandon it for the good, he owns the house. That means, what if I have bought another house and I have moved to that place, but that does not mean that I am no longer to the previous house that I owned until and unless I have sold that house. So I would be having the de jure possession. That means not the actual possession or not the physical controlled possession, but the possession which has been recognized and protected by the law. So friends, these were certain kinds of the possession that we discussed about. Now, let's discuss certain case laws which are important, and after that we shall be looking into the difference between the concept of the ownership and the possession in brief. So friends, the first case that you can see on the screen is of the Els versus Brick Gas Company in the 1886. Now, the facts of this case, as you can see on the screen, are that in this case the plaintiff was the owner of the land and he gave his land to the defendant company on lease for the purpose of excavation or erection of the gas works thereon. During this course of process, one of the men of the defendant company found a prehistoric boat which was buried 6 feet below the surface. Now this issue was with regard to the possession and the claiming, or rather the rights over that found property. So, Justice Chitty observed that the landlord was entitled to the boat against the company though it was discovered by the company, because it was observed that it became very immaterial that the landlord was not aware about the existence of the boat. He was in possession of the ground, not merely of the surface. Hence, everything that lays beneath the ground also was in his possession, and so the possession was given duly to the owner of the land and not to the company who has found it. The next very important and interesting case law is of the South Staffordshire Water Works versus V. Sherman in 1896. The facts of this case are that in the instant case, the plaintiff company appointed defendant servant to clean out the pond upon their land, and in doing so he found certain gold rings at the bottom of the pond. Dispute arose between the plaintiff company and the defendant servant as to the possession of that gold ring, to whom that gold ring would belong. It was held that the plaintiff company was in the first possession of the gold ring, and it is not the defendant who acquired no title to them. It was observed that the possession of the land care is within the general possession of everything which is attached or which is under the land. So in both the cases, if you can see that the judges are of the same opinion that you will have the possession of everything that comes beneath the land, that is attached to the land, that is under the land, or rather that is above the land. So whatever is found, whosoever is found would become immaterial while deciding the actual owner, or rather the actual beneficiary of the things that has been found when the possession is there and the ownership is there in the question. So friends, now let's discuss certain basic differences which lies between the ownership concept and the possession. Friends, as you can see on the screen, I have put a picture of the difference between ownership and possession. In the ownership picture, there is only one key which has been given. In the possession, the key has been given in return to certain amount of money. So does that mean that the ownership would not require any consideration amount? No, it literally does not mean so. So let's have a look at what are the differences between these two concepts, which is there slightly same in its nature. The meaning of the possession literally means the physical control over the thing or the object. The possessor has a better title against the whole world except the true owner. Possession is 9 points in the law. The term ownership derived from the Latin word own, which means to have or to hold a thing. One holds a thing as his own, which is called the owner, and will have all the rights of the ownership over that particular thing. Therefore, the term ownership literally means legitimate and absolute right of a person over that possessed things also, and even of the things which it does not possesses. Now the next difference is the possession is the most basic relationship between the man and the thing. Ownership is the relationship of a person with an object forming the subject matter of an ownership. That means, my friend, that to have the ownership, we have to have the possession also. So it becomes very important when we are talking about the rights, or rather the acquiring of the rights, that the possession has to be there. The relationship of the possession needs to be there between the man and the thing that is there in the conflict. The next point of the difference is that possession is prima facie a proof of the evidence of the ownership. At the same time, the ownership consists bundle of the rights, and all the rights are there as rights in rem. That means, my friend, that when you have the ownership, or rather when you are saying that I am having the possession, that would prima facie means that you are having the ownership. But if that right is there in the restrictive manner, it is not absolute in nature as we saw in the definition, that would be called as the possession only. But if that person who is having the possession over the property has an absolute right over certain property, they would be known as the ownership. The next and the last point of the differentiation is that the transfer of the possession is comparatively easier and less technical. Rather, the transfer of the ownership is in most cases involves the technical process of conveyancing. That means, my friend, that contract is of course required. Legalities or legal methods are also required. But when you are transferring certain rights which has been owned by you to somebody else, it of course becomes easier rather than shifting or transferring all your rights to somebody else. So friends, these were certain very minute differences which lies between these two concepts of the ownership and the possession. So this was all about the definition, the concepts, the essential elements, the types, the kinds, certain case laws and differences between the concept of the ownership and the possession. Friends, in the next session, we shall be looking into the different kinds of the property, because friends, the kinds of the property becomes very important to understand when we are talking about the concept of the ownership and possession at large. So till then, take care and keep reading.